Okay, in the court cases involving the PDP and the ADC, the African Democratic Congress, the Supreme Court had already indicated by asking that the counsel on both sides should file their processes early and that the court would take a look at those processes and briefs on April 22. Now that the court says it's reserving judgment in the matter, the expectation is that this will also again be treated expeditiously, considering the challenge of time. INEC having directed that submissions of register and names of candidates should be done within the window of April 21 to May 30. So we will not have to wait for too long. However, in both cases, both PDP and ADC, the major issue is, as counsel on both sides argued in their briefs, is about the internal affairs of political parties. In the case of the PDP, the outstanding cases were the judgment by the Court of Justice Omotosho and that of Justice Peter Lifo, affecting the Ibadan Convention of the PDP that was held in November. Whether, that Ibadan Convention was validly conducted or not. And of course, the Turaki group that organized that convention, they are saying that the court lacks jurisdiction. So that was the major argument. They arguing that this has to do with the internal party affairs within the purview of Section 83 of the Electoral Act 2026. Ditto for the ADC, where, okay, before I go to ADC, in the PDP case, the Court of Appeal in Abuja had nullified the Ibadan Convention, on the basis of which the Wike-led group took over the party. Now, if you go to the ADC, the issue is again about the Court of Appeal ruling on March 12, which talked about going back to status quo ante bellum, and with the David Mark group now going all the way to the Supreme Court to say, no, the jurisdiction of the court does not extend to the internal affairs of the party. These were the two major issues before the Supreme Court yesterday. Well, the judgment may be given at any time, but that judgment, what we should be interested in is what the court says about that Section 83 of the Electoral Act, whether or not the court can entertain jurisdiction. In the case of the ADC, the Court of Appeal had said they had jurisdiction over the matter, and that was why they returned the processes back to the Federal High Court, where the original matter was treated in the Court of Justice Emeka Nwite. But whatever comes out of the decision of the Supreme Court, our fear is the implications that it may have for multi-party democracy. I repeat that. The implications of the judgment that will be eventually delivered for multi-party democracy. But we won't have long to wait in this regard, as I said. But what bothers me is the fact that the Wike faction is already selling nomination and expression of interest forms. 51 million for presidential, aspiring presidential candidates, and was it 21 million for governorship candidates. And the Wike faction also having taken over the PDP secretariat, the Wike faction also continuing to behave in a manner as if it had already secured victory at the Supreme Court in a matter that is still pending before that court. That in itself raises questions, except the Wike faction in that party had already concluded that it will win anyway. So these are questions that can be raised in that particular regard.